With Chief Justice Dr. Willy Mutunga expected to exit his position in June this year and his deputy Kalpana while working on a delicate legal path, the roadmap to search for their potential successors is proving equally explosive. The bone of contention being what has been described as the decision by the National Assembly's Justice and Legal Affairs Committee to sneak in an amendment to the JSC Act of 2011 and hand the President the powers to appoint the Chief Justice, Deputy Chief Justice and the Inspector General of Police. Unlike in 2011, where the President was presented with only one name for the position of Chief Justice, this time round he will be presented with 3 names, that is, if the amendments are not quashed by the court. But what seems to be another promising legal duel, the Law Society of Kenya Wednesday knocked at the gates of the corridors of justice, with 4 advocates having been enlisted to persuade the court to quash the contested amendments.
And the effect of that amendment we shall be demonstrating in the main petition, my Lord, was that it usurped of the Constitution.
While Justice George Odunga did not grant conservatory orders as prayed, he termed the case to be that of public interest, which must be adjudicated expeditiously.
On my part, I am satisfied that the application and by extension the petition itself are urgent and ought to be heard and determined expeditiously.
This even as the Kenya Law Reforms Commission became the first institution to publicly support the amendments.
It was a procedural amendment. Parliament, in its wisdom, went further and said, okay, we are going to legislate in more details the number of candidates you are going to present to us. That was an issue of also procedure. And I would have thought that this is an issue which you also discuss with the JSC. If the JSC is agreeable to that, I don't see that there would be unconstitutionality in the issue.
While noting that the Judicial Service Commission is the only body that should be lamenting, Commission Chairperson Mbagi Ng'ang'a says they can only take issue with the amendments if the process that led to their rise was not consultative.
It is the JSC which does the interview, all those processes, and recommends the President. So that is a process which can be codified in the Judicial Service Commission. And if what went on in Parliament was with the concurrence of the JSC, I would have no issue. That is why we are saying we need to hear the JSC position on this matter, because before we make our position known.
The opposition and a section of the civil society have equally taken issue with the amendments done through an omnibus bill, terming them a threat to the very existence of independent institutions, contrary to provisions of Article 166. LSK case against the National Assembly and the Attorney General will be heard inter partes on the 13th of this month. Halligan Agade for Channel 1 News.